My name is Claire Bennett. I am 36 years old, and the moment my mother announced that my $120,000 inheritance now belonged to my brother, 22 relatives were watching me across Grandma Rose's dining room. Linda raised her champagne glass and said, "Ryan has children, you'll survive." Everyone waited for me to cry, argue, or beg. Ryan leaned back in Grandma's carved walnut chair, the one nobody had used since her funeral, and smiled like the decision had already become law. His wife whispered that I had always been independent anyway. My mother slid a waiver toward me and tapped the signature line with one manicured finger. I read 3 sentences, folded the paper, and placed it beside my plate. "I won't sign this," I said. My mother's smile hardened. She told the room I was being selfish over money Grandma clearly intended for the family's future. I finished my water, thanked the caterer, and left without touching dessert. From my car, I sent one affidavit to the probate court. At the estate closing 2 weeks later, the lawyer froze every account. 10 months earlier, I still believed grief might make my family kinder. Rose Bennett had raised my brother and me during the years our parents were building Bennett Senior Living, a regional chain of assisted living residences across western Pennsylvania. Grandma never cared about the company's glossy brochures. She cared whether residents knew who had changed their sheets. My mother, Linda, became chief executive after my grandfather died. She was brilliant in public and merciless in private. Investors called her disciplined. Employees called her only when they had rehearsed every sentence. Ryan, 3 years younger than me, became vice president of development, despite never lasting more than a year in any job Grandma had not arranged for him. Ryan was the family's golden child because his mistakes always arrived wearing the costume of ambition. A failed restaurant became market research. A totaled sports car became stress from leadership. His luxury cabin project, Cedar Crown Retreats, was described as a bold expansion even after contractors filed liens, and the bank threatened foreclosure on land he had pledged twice. I chose a different life. I became a forensic accountant and worked with hospitals, charities, and family businesses when money stopped matching the story executives told. My mother said I spent my career searching for betrayal because I lacked the courage to build anything. Grandma said I counted honestly because numbers did not care who was favored at dinner. When Grandma turned 82, she moved into a cottage behind her original farmhouse, rather than enter one of our company facilities. I visited every Tuesday and Saturday. We balanced her checkbook, made tomato soup, and watched old courtroom dramas. Ryan appeared on holidays, usually with photographers from a company newsletter, and children coached to hug her at the door. Grandma's estate was not enormous by billionaire standards, but it was substantial. She owned the farmhouse, 60 acres of orchard land, municipal bonds, and founder shares in Bennett Senior Living. Her revocable trust provided $120,000 to each grandchild, education funds for the great-grandchildren, and the remaining shares to a charitable foundation supporting low-income seniors. She named my mother as executor and initial trustee because Linda understood the company. She named retired Judge Miriam Cole as trust protector because Grandma understood Linda. The document allowed Miriam to remove any trustee who concealed records, pressured a beneficiary, used estate assets for personal debts, or attempted to alter distributions through fraud or coercion. I knew about the clause because Grandma had shown me the trust after Ryan asked her to guarantee a loan. She was not asking me to keep secrets. She wanted one person in the family to understand the difference between helping someone and financing his refusal to change. "Love can be generous," she told me. "It should never be blind." The first warning appeared 4 months before Grandma died. Her pharmacy called me because 2 automatic payments had failed. Grandma had enough money in her household account to cover medication for years. When I logged in with the access she had authorized, the balance had fallen from $38,400 to less than $6,000 in 6 weeks. The withdrawals were labeled property maintenance, but the farmhouse roof had not been touched, and the orchard crew had not been paid. 3 transfers went to Bennett Development Services, a company Ryan had formed for Cedar Crown. Another payment covered the overdue insurance premium on his lake house. None of the transactions carried Grandma's usual written notes. I drove to my mother's office and asked for an explanation. Linda did not deny the transfers. She called them temporary advances that protected the family's broader interests. Ryan's project would recover once permits cleared, she said, and Grandma's cash was sitting idle. I reminded her that a power of attorney was not permission to borrow without consent. Her voice became soft, the way it did when anger had already made a decision. She said Grandma had approved everything verbally and was becoming too forgetful to sign each routine document. Ryan accused me of turning a family cash flow issue into an investigation. Then he asked why I cared, since the trust would eventually make me whole. That sentence stayed with me. If they believed my inheritance would replace whatever disappeared, then Grandma's estate was no longer a responsibility to them. It was a reserve account. I asked to see the loan agreements, board approvals, and notes from Grandma's financial advisor. Linda said I was not a trustee and ordered the receptionist to end the meeting. Grandma was alert when I visited that evening. She remembered the pharmacy call, the amount in her account, and exactly how many jars of peaches we had canned in August. When I mentioned Bennett Development Services, she stared at me for several seconds and said she had refused Ryan twice. She had signed no loan and had authorized no transfer. I recorded nothing secretly. Instead, I asked whether she wanted her attorney present. She called Samuel Ortiz, the estate lawyer who had drafted the trust. Samuel came the next morning with his paralegal and a mobile notary. Grandma signed a written revocation of all financial gifts to Ryan's companies and directed Linda to restore the money within 30 days. Samuel also prepared a memorandum describing Grandma's capacity, the questions she answered, and her reasons for protecting the estate. He sent copies to Linda, the bank, and Judge Miriam Cole. My mother responded with a furious email accusing me of isolating an elderly woman and manipulating her against the son who had given her great-grandchildren. 2 weeks later, Linda moved Grandma into Maple Ridge House, the company's most exclusive residence, claiming the cottage needed emergency mold remediation. I arrived for my Tuesday visit and found the locks changed. Staff said only Linda and Ryan were approved for contact until Grandma adjusted to the move. No doctor had recommended isolation. I called Samuel. He filed a demand for access and reminded the facility that Grandma remained legally competent. By the next afternoon, I was allowed inside, but only in a glass conference room with a manager sitting nearby. Grandma looked exhausted. Her hearing aids were missing, and a sedating medication had been added without a clear explanation. She squeezed my hand and asked why Linda kept bringing papers after dinner. Before she could describe them, the manager interrupted and said conversation should remain positive. I asked for Grandma's medication chart and was told health records required trustee approval. I was not her healthcare proxy, but Samuel obtained a release. Grandma had signed months earlier. The chart showed that Linda's preferred physician had diagnosed probable cognitive decline after a 10-minute visit. The same day, Ryan witnessed Grandma's signature on a new property management agreement, giving Bennett Development Services authority over the orchard. The signature looked shaky, but the capital R was formed exactly the way Linda wrote it. Samuel petitioned for an independent capacity examination. Before the hearing occurred, Grandma fell during the night and fractured her hip. The facility reported that she had tried to walk without assistance. A nurse later told me privately that Grandma's call button had been disconnected during a room renovation, and staff had documented checks they never performed. Grandma survived surgery, but developed pneumonia. I stayed at the hospital whenever visiting rules allowed. Linda appeared with flowers for photographs and spent most of her time speaking to administrators. Ryan came once, asked whether Grandma had mentioned his project, and left before she woke. She died 11 days later with Samuel and me beside her bed. Her last clear request was not about money. She asked Samuel to make sure the orchard remained open to the neighborhood school that visited every autumn. Then she looked at me and said, "Do not let them turn my silence into permission." Samuel wrote the words in his notes, but grief kept me from understanding how soon they would matter. At the funeral, my mother delivered a polished speech about sacrifice, legacy, and family unity. Ryan cried when cameras turned toward him. During the reception, Linda told me probate would be simple if nobody created unnecessary conflict. She asked me to send all financial questions through Ryan, because he was now handling operational continuity. 3 days later, I received a beneficiary notice stating that Grandma's trust had been amended 6 weeks before her death. My $120,000 distribution was reduced to $1. Ryan's distribution increased by the same amount, and Bennett Development Services received a 5-year option to purchase the orchard below market value. Attached to the amendment was a notarized statement saying I had voluntarily surrendered my inheritance because Grandma had already funded my education, and because Ryan's children represented the family line. My signature appeared at the bottom. The notary seal belonged to a woman named Patricia Vale. I had never met her, and I had signed nothing. I called Samuel before calling my mother. He sounded genuinely shocked. The amendment had not been prepared by his office, even though the first page copied his formatting. The witness block listed Ryan and Maple Ridge's executive director. Grandma's signature was dated 2 days after the independent capacity petition had been filed. Samuel told me not to confront anyone until we preserved the records. We requested the original document, the notary journal, facility visitor logs, medication records, and electronic metadata. Linda's attorney replied that the originals were secured and accused us of harassing a grieving family over a valid estate planning decision. The next morning, Ryan posted a photograph of himself at the orchard with his children. His caption said, "Grandma had entrusted the next generation with protecting her legacy." A developer's survey stakes were already visible behind them. Cedar Crown's lender had scheduled a foreclosure hearing in 21 days. The discounted orchard option was clearly meant to rescue him. I asked my mother to meet privately at Grandma's farmhouse. Linda arrived with Ryan and a family attorney. She said Grandma had changed her mind after realizing I did not need assistance. Ryan had a wife, children, payroll, and obligations. I had an apartment, a career, and no dependents. "You'll survive," she said, as if survival were a gift. I placed the forged waiver on the table and asked Linda to identify when I signed it. She said the notary could explain. Ryan said my obsession with signatures proved why Grandma found me exhausting. Their attorney warned that contesting the trust could trigger a no-contest clause and leave me with nothing beyond the $1. Samuel had already reviewed that clause. It punished frivolous challenges, not good faith claims of forgery, coercion, or fiduciary misconduct. More importantly, Grandma's original trust required an automatic independent review whenever a trustee benefited from an amendment made during a documented capacity dispute. Linda either had not read that provision or believed nobody else had. I did not reveal it. I asked one final question: would they voluntarily suspend distributions until the signature was verified? Linda refused. She said the estate closing would proceed in 2 weeks and that relatives had been invited to celebrate Ryan's stewardship. She expected me to attend, accept Grandma's decision, and stop embarrassing the family. That evening, Samuel and I prepared a sworn affidavit. I stated that the waiver was forged, listed my locations on the signing date, attached time-stamped work records, and requested activation of the trust's protective review. I also described the unauthorized transfers from Grandma's account and the pressure applied after her move to Maple Ridge. Judge Miriam Cole received the affidavit through the court's secure filing system. Under the trust, its acceptance immediately suspended Linda's authority over contested assets. Miriam could freeze distributions, replace the trustee temporarily, and demand records from any company that had received estate funds. She confirmed receipt but instructed us not to publicize the review. I returned to work and waited. My mother interpreted my silence as surrender. Relatives began sending cheerful messages about the estate closing, asking whether I planned to apologize to Ryan. An aunt told me Linda had arranged champagne, a photographer, and a presentation showing the orchard's transformation into luxury cottages named after Grandma. The night before the dinner, Patricia Vale, the notary listed on my waiver, called Samuel. She had learned about the subpoena from her licensing board. Patricia worked in another county and had been attending her daughter's wedding in Arizona on the date of the alleged notarization. Her seal had disappeared from a desk drawer at Maple Ridge months earlier. Patricia's journal contained no entry for Grandma, me, or the amendment. She remembered notarizing vendor contracts at Maple Ridge the previous spring, while Linda and the executive director were present. A security log showed Ryan entering the administrative office after Patricia left. The missing seal had never been reported because Patricia assumed it was packed in another case. Facility metadata added another layer. The amendment file had been created on Ryan's laptop, edited on Linda's office computer, and printed from Maple Ridge's executive suite. The scanned signature page was inserted later. A deleted draft recovered from backup contained a note in the margin. Need Claire waiver so transfer appears balanced. Samuel asked whether I still planned to attend the estate closing. I said yes. Not because I wanted a dramatic confrontation, but because Linda had invited relatives, lenders, and business partners to witness what she believed was Ryan's victory. If the review changed control of the estate, they deserved to hear it from the lawyer rather than through another family story. The dining room looked almost exactly as it had during Grandma's last birthday, except her photographs had been replaced by architectural renderings. Ryan stood beside a poster titled Rose Orchard Legacy Village. Linda wore Grandma's pearl necklace. A banker from Cedar Crown's lender sat near the front with two representatives from a development firm. My place card was at the far end beside the kitchen door. On my plate rested the waiver they wanted me to sign again, this time with 3 relatives listed as witnesses. Linda kissed my cheek and whispered that accepting reality would be less painful than losing publicly. I sat down, opened my notebook, and said nothing. After dinner, Samuel stood with a sealed folder. Linda introduced him as the attorney who would confirm Grandma's final wishes. Samuel corrected her. He explained that he represented the original trust, not the disputed amendment, and that Judge Miriam Cole had activated the protective provisions after receiving a sworn forgery claim. Ryan's smile vanished first. Samuel read the court order slowly. Every estate account was frozen. Linda was suspended as executor and trustee. The orchard option was void pending review. Bennett Development Services was prohibited from selling, pledging, or transferring any property connected to the estate. An independent fiduciary would take control by morning. The banker closed his folder. One developer began whispering into his phone. Linda demanded to know who had filed the claim. Samuel said the affidavit was mine, and that supporting evidence included employment records, notary testimony, bank transfers, facility logs, and electronic metadata. Nobody touched the champagne that had already been poured. Ryan stood and accused me of stealing from his children. I reminded him that the money had never belonged to them. Linda said Grandma would be ashamed that I had turned a private disagreement into a legal attack. Then Miriam Cole entered through the side door with a court-appointed fiduciary and 2 investigators from the State Elder Abuse Unit. Miriam did not raise her voice. She informed Linda that the trust required immediate preservation of documents and that destruction, concealment, or retaliation could create separate liability. Investigators collected laptops from the office and issued notices to Maple Ridge, Bennett Senior Living, Ryan's company, and the estate's banks. The celebration ended in less than 12 minutes. Relatives who had congratulated Ryan avoided his eyes. His wife gathered the children and left through the kitchen. Linda followed me onto the porch and grabbed my arm. She said I had no idea what I had done to the company, the family, or Grandma's name. I removed her hand and said, I filed one truthful document. She called me cold. I told her the accounts were frozen because the trust anticipated exactly this kind of conduct. Her face changed when she realized Grandma had built the safeguard years earlier, before illness, before the orchard option, and before anyone could blame me for influencing her. By midnight, my phone showed 38 missed calls. Ryan alternated between threats and offers. He said Cedar Crown would collapse unless I withdrew the affidavit. He promised to return half the inheritance, then all of it, then the farmhouse too. Linda left a voicemail saying she would tell everyone I manipulated Grandma for years. Samuel instructed me not to negotiate. The affidavit could not simply be withdrawn once the trust protector found independent evidence of fraud. The review now belonged to the court. An emergency order required complete accountings from Linda, Ryan, Maple Ridge, and Bennett Senior Living for the previous 3 years. The first records showed that Grandma's missing household funds were only a small part of the problem. Linda had billed the estate for private nursing aides who were actually assigned to company residents. Ryan charged orchard maintenance for work performed at Cedar Crown. Maple Ridge collected premium care fees while leaving Grandma without required supervision. Investigators also found that Linda had used Grandma's founder shares as collateral for a corporate credit line without disclosing the trust restrictions. When the company's occupancy rates fell, the borrowed money covered executive bonuses, Ryan's development deposits, and a public relations campaign praising the family's commitment to seniors. The most painful evidence came from Grandma's room. A maintenance worker had preserved a small digital recorder found behind her nightstand because he feared it would be destroyed. Grandma used it to dictate reminders after her hearing worsened. Several recordings captured Linda and Ryan bringing documents late at night. In one recording, Grandma repeatedly asked for Samuel. Linda told her he was unavailable and that signing would allow the orchard workers to be paid. Ryan said Claire had already agreed to give up her share. Grandma answered, Claire would tell me herself. A nurse then mentioned the evening medication, and the recording ended. Another file captured the executive director, complaining that the signature did not look steady enough. Linda replied that nobody expected an 82-year-old woman with pneumonia to write perfectly. Ryan joked that my signature would be easier because they had dozens of examples from company holiday cards and previous tax forms. When Samuel played the recordings for me, I felt no triumph. I heard Grandma struggling to stay awake while the people she had trusted converted her weakness into paperwork. The inheritance mattered because the forgery revealed their plan, but the money was no longer the center of the case. Her right to decide had been stolen first. Linda requested a private settlement conference. She arrived with 2 attorneys and an offer that would have made most people pause. I would receive $500,000, the farmhouse, and a public statement blaming outside advisors for administrative errors. In exchange, I would challenge the recordings, support Linda's reinstatement, and release all claims. Ryan added that the company employed 800 people and served vulnerable residents. If regulators lost confidence, innocent workers would suffer. He said I could protect Grandma's true legacy by keeping the scandal contained. I asked why protecting residents required forged waivers, diverted medication funds, and a below-market land transfer to his failing project. Linda said families make imperfect decisions under pressure. I told her this was not one decision. It was a sequence: taking money, restricting access, changing medication, fabricating signatures, stealing a notary's seal, and inviting witnesses to celebrate the result. Samuel ended the meeting when her attorney suggested my grief had distorted my judgment. The smear campaign began the next day. Anonymous accounts accused me of exploiting an elderly woman. Former family friends called my employer, claiming I used confidential information for personal revenge. Linda sent relatives a timeline that omitted the independent capacity request and described Grandma's hospitalization as proof that I had stressed her. My firm placed me on paid leave while its ethics committee reviewed the allegations. I cooperated fully and provided the court filings, authorization records, and Samuel's correspondence. After 9 days, the firm cleared me and issued a statement that my actions were consistent with legal and professional duties. Linda's story lost its first public test. Maple Ridge employees then began speaking. One nurse admitted she had been ordered to document visits that never occurred. A medication aide said Linda pressured the physician to increase sedatives before document signing meetings. The executive director had received a promised promotion within Bennett Senior Living if the Orchard option closed. The physician insisted the medication was appropriate, but timestamps showed prescriptions issued before he examined Grandma. His notes copied language from Linda's emails. The state medical board opened a review. Maple Ridge lost its top quality rating, and families demanded records for other residents whose finances had been managed by company executives. What began as an estate dispute widened into a corporate investigation. Auditors found that Bennett Senior Living had charged residents for premium staffing levels while moving payroll funds into expansion accounts. Some residents paid for private aides who appeared only on paper. Linda had used Grandma's reputation to shield a business that was quietly running out of cash. Ryan's Cedar Crown project entered foreclosure. He blamed me publicly, but lender records showed default notices began months before Grandma's death. The Orchard option had been presented to the bank as guaranteed collateral even though the trust had not approved it. His rescue plan depended on everyone accepting the forged amendment without scrutiny. Patricia Vale surrendered her damaged seal and testified before the grand jury. Security video from Maple Ridge showed Ryan entering the office where it had been stored. His phone contained a photograph of the seal beside a message to Linda. "We have what we need. Just make sure Claire's sample is clean." The family attorney who attended my farmhouse meeting withdrew from representing Linda after learning the waiver might be forged. He produced notes showing Linda had described my signature as already obtained. He had warned her not to proceed without independent counsel for Grandma, but she told him Samuel was creating unnecessary obstacles. 6 months after the estate closing, the probate court removed Linda permanently as executor and trustee. Miriam appointed a professional trust company, ordered a complete restoration accounting, and invalidated the disputed amendment. My original $120,000 distribution was reinstated, but no beneficiary could receive money until the missing assets were traced. The judge also voided the Orchard option and prohibited Bennett Development Services from entering the property. A conservation group offered to manage the land temporarily, keeping workers employed and school visits scheduled. For the first time since Grandma died, the Orchard was discussed as something other than collateral. Criminal charges followed after the financial audit and recordings were authenticated. Linda was charged with elder financial exploitation, forgery, conspiracy, and fraudulent use of trust assets. Ryan faced charges involving forged documents, identity misuse, attempted theft, and false statements to a lender. The Maple Ridge executive director was charged separately. Their attorneys insisted the family believed Grandma wanted to help Ryan. Prosecutors answered with the revocation she had signed, the capacity memorandum, the recordings, the stolen seal, and the draft note requiring my waiver to make the transfer appear balanced. Intent was no longer hidden behind family language. Ryan accepted a plea agreement first. He admitted using my signature, presenting the Orchard option to his bank, and participating in the late-night signing meetings. In exchange for cooperation, several charges were reduced. His wife filed for divorce after discovering he had also pledged their home against undisclosed business debt. Linda refused to cooperate for almost a year. She continued telling relatives that I had destroyed a company Grandma loved. Then investigators proved she had moved $1.8 million through consulting contracts controlled by former executives. Facing trial, she pleaded guilty to financial exploitation, conspiracy, and falsifying estate documents. The court sentenced her to prison, ordered restitution, and barred her from managing elder care organizations or serving as a fiduciary. Ryan received a shorter sentence, financial penalties, and restrictions on future business borrowing. The executive director lost her license and cooperated in cases involving other residents. Bennett Senior Living did not vanish overnight. A court-supervised restructuring removed Linda and Ryan, sold unprofitable expansion properties, and installed independent resident advocates. Several facilities were transferred to a nonprofit operator. Employees who had reported staffing fraud kept their jobs and received whistleblower protection. My inheritance was eventually paid from recovered funds, but I did not use it for the apartment or vacation relatives assumed I wanted. I placed half in a legal support fund for families contesting financial abuse in care facilities. The other half restored Grandma's farmhouse and financed the Orchard School program for 5 years. At the final estate accounting, Samuel handed me a sealed envelope Grandma had left with him before entering Maple Ridge. She wrote that fairness did not mean giving everyone whatever they demanded. It meant allowing each person to face the consequences of his own choices. She told me not to confuse boundaries with cruelty. She also said that the $120,000 was never a reward for being the good grandchild. It was a share she had chosen deliberately, equal to Ryan's original share, because love should not be measured by who produced heirs or created the loudest emergency. I read that sentence 3 times before I could continue. Linda sent letters from prison. The first blamed Ryan. The second blamed the company's lenders. The third said she was ready to forgive me for humiliating the family. None acknowledged Grandma's fear, the forged signature, or the sedating medication. I gave every letter to Samuel without replying, because an answer would have become another doorway back into her version of events. Ryan wrote after completing a financial counseling program. He admitted he had treated every crisis as a reason for another rescue, apologized for the forged waiver, and asked for Orchard money for his children. Through counsel, I answered that the children would receive every benefit Grandma lawfully created, but no adult would ever borrow against those funds again. The farmhouse reopened the following autumn. We repaired the porch, preserved Grandma's kitchen, and converted the front room into a small resource center where families could meet elder law volunteers. The orchard workers planted a new row of apple trees along the school path. No cottage development signs remained. On the first field trip day, 60 children arrived in yellow buses. They learned how to press cider, identify damaged branches, and read the rings of a fallen tree. One teacher asked why the program was named Rose's Choice. I said because the land survived only when her decisions were treated as hers. My extended family remained divided. Some relatives apologized for attending the estate celebration and believing Linda's version. Others said legal action had been too harsh, even after the convictions. I stopped arguing. Anyone who needed forgery and financial abuse to become a misunderstanding was not asking for facts. They were asking for comfort. I sold neither the farmhouse nor my restored trust interest. The professional trustee converted part of the estate into the Rose Bennett Elder Dignity Fund, exactly as the original document directed. The fund supports transportation, medication access, and independent advocates for seniors whose relatives control their finances. 3 years after Grandma's death, Bennett Senior Living no longer carries our family name. The new operator publishes staffing numbers, separates resident funds from corporate accounts, and allows private family visits without executive approval. Reform did not erase what happened, but it prevented silence from becoming policy. I still work as a forensic accountant. The cases feel different now. When executives call missing money a family matter or a temporary adjustment, I hear my mother saying Ryan had children and I would survive. Survival is not consent. Competence is not permission to take from the person least likely to collapse. Every November, I make Grandma's tomato soup at the farmhouse for the orchard staff and volunteers. There is no formal speech, no family crest, and no seating chart ranking who matters. The children choose the first apples, and the oldest workers choose the first bowls. Nobody has to earn a place by remaining useful. People sometimes say one affidavit destroyed my family. That is the version Linda preferred because it made honesty sound violent. The affidavit did not forge a waiver, steal a notary seal, medicate Grandma, divert her money, or pledge her orchard. It simply required those choices to be examined under light. My mother gave my inheritance to her golden child because she believed I would absorb the loss quietly, just as I had absorbed years of smaller insults. She was right that I could survive without the money. She was wrong to believe survival meant she owned my silence, my signature, or the right to rewrite Grandma's final choice. At the estate closing, their smiles disappeared when every account was frozen. Mine did not appear in their place. I felt grief, anger and relief, but not victory. Victory came later, when the orchard reopened, residents received advocates, and Grandma's final decisions were carried out without anyone translating them into convenience. I never returned to the old family table. I built another one in Grandma's front room, scarred by years of soup bowls and school projects. Around it sit people who understand that love does not require forged signatures, inherited obedience, or public humiliation. It requires the courage to let another person's choice remain their own.